committee to start. Usually when there's a voting period in the House and committee starts at 3:30, it takes them 5-10 minutes to walk over from one part of the Parliament over to the West Block. So I imagine they'll still be another 5 minutes late. So as soon as the committee starts, we'll switch right over. We'll stay on this stream, I'm saying, but I will change over from the House to the committee. In the meantime, as I'm saying, we're just going to tune into the House and see what's going on here, which is probably not much, but...
And the witnesses we heard were clear. 3 years of cumulative physical presence is the fairest and most realistic measure of a genuine connection to Canada. This standard is based on an already well-established principle. In order to apply for citizenship, a permanent resident must have lived in Canada for 1,095 days over the past 5 years. 3 years is the time it takes to learn about our institutions and to understand our values and to integrate into Canadian life. For Canadians born abroad, this same requirement ensures a balance. It keeps citizenship open to the world without detaching it from its national roots. We want citizenship to remain a concrete commitment, not just an administrative legacy. 3 years is proof of a real, lived, and felt connection. This is a flexible and modern model. We need to keep in mind that the world is constantly changing. Canadians travel, study, and work abroad. They are researchers at other universities, they're diplomats, they're entrepreneurs, they're artists and teachers. Bill C-3 recognizes these realities. The bill allows Canadians living outside Canada to maintain their genuine connection, their deep connection to Canada. And at the same time, the bill ensures that each generation has also lived a significant part of their life here. The bill stipulates that a parent born abroad must have spent at least 3 cumulative years in Canada before the birth or adoption of their child. These years do not have to be consecutive. They can be spent studying, working, or engaging in family or community activities. This is a modern, flexible, and inclusive approach that respects people's life journeys while preserving the integrity of citizenship. Mr. Speaker, now I'd like to address the issue of a strong intergenerational link. Canadian citizenship is a living legacy. This bill ensures that from generation to generation, the link with Canada remains concrete and meaningful. By making citizenship by descent possible beyond the first generation, by requiring this substantial 3-year connection, we're striking a balance between openness and responsibility. We're not closing the door. We're anchoring it firmly in Canadian soil. We're saying to every family, your citizenship is a right, but it's also a commitment to the community, to our democracy, and to our shared values. This is a fair and sustainable response to the Supreme Court. This reform responds to the 2023 decision of the Ontario Superior Court of Justice, which ruled that first-generation restrictions on citizenship by descent were unconstitutional. So Bill C-3 broadens access, but in a balanced way. It ensures that children born abroad to Canadian parents inherit not only status, but also have a real Canadian experience. 3 years is the time it takes to integrate, to work, to study, to build friendships, and to contribute to Canadian society. It's the time it takes to love Canada, not from afar, but from right here within the country. And that's why we say you have to experience Canada. You have to live Canada, its culture, its art, its values, and its respect for institutions. Citizenship is something that's lived, not just inherited. Mr. Speaker. So the substantial 3-year connection is not a barrier. It's evidence of attachment to Canada. So it's a commitment to a country that is distinguished by its openness, its diversity, and justice. This bill reminds us that citizenship is not passed on just through blood or papers, but through experience, contribution, and solidarity.
Mr. Speaker, obviously we need some balance. We need to ensure that the 3-year threshold applies uniformly to all Canadians born or adopted abroad. It aligns citizenship by descent with the criteria for naturalization, ensuring complete consistency and complete fairness. Mr. Speaker, this reinforces a simple idea. In Canada, citizenship is based on meaningful participation in the life of the nation. It's a shared responsibility, a shared bond, a pride to be nurtured. In conclusion, Mr. Speaker, this is citizenship that respects our values, our country, and human values. Mr. Speaker, Bill C-3 isn't a simple administrative update. It's a statement of principle about what it means to be Canadian in 2025. We live in a world of mobility, of diversity, and of complexity. This bill does not restrict. It brings people together. It doesn't close doors. It ensures the human thread that connects every citizen to Canada remains alive and sincere. Because being Canadian, Mr. Speaker, it's more than having a certain status. It's a sense of belonging. It's a bond of the heart, a bond of memory. It's the pride of a country built by those who live there, who contribute to it, and who have chosen it. And 3 years, Mr. Speaker, it's not a long time to learn to love a country, but it's enough to never want to leave it, as was my case, Mr. Speaker. After 3 years, Mr. Speaker, I loved this country, and I really found that it was very difficult to leave this great country of Canada. So I invite you, honourable colleagues, to support this bill, which is fair. It's a bill that's balanced, and a bill that is very human. It will ensure that Canadian citizenship remains a living promise, that of a Canada that is united, open, and proud of its citizens around the world. And on that, thank you, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for St. Albert Sturgeon River.
Well, thank you, Mr. Speaker. I would be curious if the honourable member across the way supports a basic background check before automatic citizenship is granted to a Canadian born abroad who gains citizenship by descent, because as the Liberal bill was drafted, it would provide automatic citizenship without any kind of security check. Conservatives brought forward an amendment at committee to fix that. What is his position on the Conservative amendment?
L'honorable député de...
The honourable member for Bourassa. Well, thank you very much, Mr. Speaker. And I'd like to thank you for the opportunity to answer that good question from my colleague. I can say simply that this bill will take into consideration national security. It takes into consideration stability. It takes into consideration verification. So I would invite the member to look at the bill. I thank them for their amendment. Our government is working in collaboration with all members.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I want to go back to the question that was just asked. You know, it's interesting. There was a report that when the Conservatives were in government that came out from a committee, one of our standing committees, and it indicated that in the recommendation that the CIMM committee report done at the time of the Harper government made this recommendation, and you can actually see it in the Conservative report, and I quote, background checks are only appropriate for candidates seeking a grant of citizenship as opposed to those for whom citizenship is a birthright. Now, the debate we're talking about is a birthright. So we have the Conservative Party who have forgotten about that report, even though their leader of the Conservative Party was around at that time, and they've taken a reverse position. I wonder if the member would agree that the Conservative Party needs to be more consistent with public policy.
L'honorable député de...
The honourable member for Bourassa. Thank you very much, Mr. Speaker, and I thank my colleague for that question. I agree on the issue of consistency, but I also think that this question linked with dissent, which was rejected at the time by the Conservatives and now which has come back, I think it's unacceptable. That having been said, we also have to be careful, Mr. Speaker. When we always want to create a link between immigration and security and create that stigma, you have to be very careful. This is a stigma that affects immigrants and people who were born here as well. The Honourable Member from Mirabel. Thank you, Mr. Speaker. And I'd like to thank my colleague for his speech. Listen, Mr. Speaker, yesterday we debated a committee report here in House, and the Parliamentary Secretary to the Leader of the Government rose and said that this wasn't, the place to have that debate here in the House of Commons. He said committees will take care of that. Committees can do their work. But when the committee here, and when committees do their work, we'll look at what, the work the committee has done here in the House. He said yesterday that we were wasting our time here in the House. Well, today we have Bill C-3 here in the House, and it's come with amendments at report stage where the committee has done its work. The committee heard witnesses, there was consensus, there were amendments that were passed. The parliamentary budget officer came to committee, the minister came, she wasn't able to give us any numbers, Mr. Speaker, and today, now, the next day, the parliamentary secretary is saying that here it's up to the House to review and reject the committee's work and its amendments. So what kind of liberal do we have to believe here? Yesterday's liberals or today's liberals? The Honourable Member for Bourassa. Well, first of all, I'll answer my colleague's question. So who do we need to listen to? Well, all the liberals who were chosen by Canadians across this country. But I also want to say something. An amendment is one thing, but completely changing a bill is something else. When you have amendments that change the spirit of the bill itself, that's really a problem. It's not up to the... we're not going after the committee for doing its work, but here the spirit of a bill has been changed, and we need to work to fix that.
The Honourable Member for St. Albert, Sturgeon River.
Thank you, Mr. Speaker. I rise to speak on Bill C-3, an act to amend the Citizenship Act brought forward by this Liberal government. This bill eliminates the first-generation limit for the granting of citizenship by descent, and it drastically expands the granting of citizenship to persons born abroad who have little to no connection to Canada. In short, this bill is radical, it's reckless, and it significantly undermines confidence in our immigration system. But then again, it should come as no surprise that we have this awful piece of legislation brought forward by these Liberals, because these Liberals across the way, after all, subscribe to a radical, globalist, post-nationalistic ideology. Justin Trudeau infamously said that Canada is a post-national state with no core identity. It follows that if Canada has no core identity, then Canadian identity means nothing and Canadian citizenship means nothing. That is the vision.
Okay, I hate to interrupt Cooper, but the committee's on.
Benefit of the witnesses, though please maintain a respect, like a finger distance like this from the microphones, just to protect the hearing of the interpreters, as we do have simultaneous interpretation into English or French, depending on the language of your preference. For those on Zoom, I will assume, but I'll repeat it again, that you're familiar with the raising your hand functions. Members here that want to ask the witnesses questions raise their hands. I will recognize them. I'm not asking that questions go formally through the chair again. For purposes of a more dynamic conversation, it's okay to talk to the witnesses. Just be respectful of that dynamic. If I have to rein it in, obviously I will. Just a bit of housekeeping, because we started with about a 10-15 minute delay. I don't know if members prefer to go over or whether we will cut it. We do have 3 hours today. or whether we'll cut it at 6:30. 6:30 is good. So look, we have plenty of time for the witnesses today, and then this round, and then the next round. So we'll just adjust on the fly, and I'll let you guys know what the cutoff time is, just to allow changeover, and so we get a full set of questions into the witnesses. For our first panel, we have with us Mr. and Mrs. Best, Ronald and Michelle, from the Brantford Police Association, Jeremy Morton, the president, and from the London Abused Women's Centre, Jennifer Dunn, the executive director by video conference, and from the Police Association of Ontario, Mark Baxter. Je tiendrai à rappeler aux témoins qu'ils ont.
Let me remind the witnesses, Mr. and Mrs. Best, you have 5 minutes total. Mr. Morton, Ms. Dunn, Mr. Baxter, you have 5 minutes each, and after that, we will proceed with rotation for members of the committees to ask their questions. Without further ado, I will give the floor to Mr. and Mrs. Best.
And then I'll proceed with Mr. Morton, Ms. Dunn, and Mr. Baxter, 5 minutes each. Thank you and welcome.
Good afternoon, and thank you for allowing us to share our story of our beautiful daughter, Kelly. My name is Michelle, and my husband, Ron, is beside me, and we are here today as grieving parents. At 28 years old, Kelly had built a full and beautiful life. She was a daughter, a sister, an aunt, a granddaughter, a fiancé, and a friend to many. She and her fiancé, Travis, were planning their dream wedding for this June. We were supposed to watch her walk down the aisle. On January 15th, our world stopped. Kelly was killed that day. We were on our way to meet her to prepare for her grandfather's funeral, who had passed just 48 hours earlier. Her fiancé, Travis, and I got the call from the RCMP asking us to meet them. As we drove there, I called my husband and my son, our son Michael. When we arrived, the RCMP told us the complete unthinkable, that our daughter was gone. Over the next few days, we learned that the man who killed her had a warrant for his arrest issued at the time of the incident. He had breached bail conditions for previous crimes involving drugs and theft. That morning, he had stolen a truck, driven it towards Port-de-Chaperie, and caused a crash that killed my daughter. After the collision, he kicked out the truck's window and fled on foot. When he was caught, he had a large amount of methamphetamine in his system. He was taken into custody, appeared before a judge, and unbelievably was later granted bail. Again.
What?
Despite killing our daughter while out on a warrant, the system decided to give him yet another chance.
What?
We attended the bail hearing along with our MLA and Mayor of Port-de-Chaperie and family members. The judge ruled that he could be released to a behavioral health unit in Winnipeg, Manitoba, once a bed became available. He was ordered not to drive, not to use drugs, and to follow the law. When the spot became available, he was transferred to that facility. We believe within hours he had escaped again. To this day, we do not know how long he was in that facility. When we found this out, my stomach sank with the same sick feeling I had the day Kelly was killed. My greatest fear was that he would hurt someone else or flee. And why wouldn't he? That behavior was entirely predictable. The judge had assured us that if he breached bail again, a warrant would be issued immediately. But there was already a warrant out for his arrest when he killed my daughter. What good are these reassurances? They mean nothing. This man was granted bail 3 times in 2 weeks before Christmas 2024. On New Year's Eve, he breached his conditions again and a warrant was issued. In 14 days before he killed my daughter, he stood before a judge 3 times. 3 times he was given bail. 3 times he walked away. Why does someone who shows no respect for the law, the police, the judges, or for society keep getting another chance? We hear a lot these days about rights, constitutional rights, individual rights, the rights of the accused. But what about our rights? What we do know is that what we're doing right now is not working, and we need change. The definition of insanity is to continue to do the same things in the same manner, repeatedly, and expect a different outcome. In my view, this is where we are at in the criminal justice system. What about Kelly's right to safety? What about our right to live in a country where the laws protect the innocent, contributing people to our society? Who's defending those rights when repeated offenders are released again and again, only to reoffend, sometimes within hours? Our communities are in crisis. Our justice system is broken. And somewhere along the way, we've started to accept this as normal. It's not normal, and it's not acceptable. If you hear anything from me today, hear this. The cost of these failures is measured in lives, in grief, in trauma, and in fear of repeated criminals on our streets. As a mother, as a Canadian, I expect better from my government. I expect that you will fix a system that keeps putting dangerous people back on our streets. We need you all to do the hard work, fix our broken system. It's your job, and it's what we expect. Thank you for having us.
Thank you, Ms. Best. Mr. Best, do you want to, we have a minute or so, perhaps a little more if you want to say a few words.
No, I think that we can cover it in the questions that we take. I think that's fine. Thanks, Mark.
Thank you. Mr. Morton, up to you.
Mr. Chair, members of the committee, good afternoon, and thank you for the opportunity to appear before you today. My name is Jeremy Morton, and I serve as president of the Brantford Police Association, representing 330 frontline police officers and civilian personnel who work proudly to serve the citizens of Brantford, Ontario. I also want to acknowledge that I appear here as part of the broader Canadian Police Association, which represents more than 60,000 frontline police personnel across the country. From large urban centres to small and mid-sized communities like mine, police associations are united in supporting meaningful, practical bail reform that addresses the ongoing challenges posed by serious, violent, repeat offenders. The introduction of Bill C-14 last week by Minister of Justice Sean Fraser represents an important and welcome step in that direction. As CPA President Tom Stamatakis has said, this legislation responds to long-standing calls from police associations across Canada to strengthen public safety and ensure that individuals who repeatedly commit violent offences face appropriate consequences. We appreciate that the government has listened to these concerns and taken action. In Brantford, as in many parts of Canada, our officers routinely arrest the same individuals multiple times in a single year. Those arrests are made professionally, reports are completed, and cases are brought before the court. Yet far too often, these same offenders are released almost immediately without sufficient supervision or consequences for breaching their conditions. This revolving door of arrest and release drains police resources, frustrates victims, and erodes public confidence in the justice system. That loss of confidence is not theoretical. It's something we hear directly from residents and business owners who are tired of seeing the same individuals reoffending in their neighborhoods. It also affects the morale of officers that take pride in their work and want to know that the system they serve is fair, effective, and accountable. Bill C-14 proposes targeted measures that will help address these issues, including strengthening bail provisions for repeat violent offenders and assuring that community safety is a central consideration in release decisions. These are practical, evidence-based reforms that can make a real difference in keeping our communities safe. Of course, no piece of legislation will solve every problem on its own. Implementation will matter. And continued investments in police services, Crown attorneys, and correctional personnel will be essential in making these changes effective. But Bill C-14 is a significant and positive start. Finally, I want to emphasize that public safety should never be a partisan issue. Canadians expect their elected representatives to work together to find common sense solutions that protect communities and respect the rights of all. Police associations across Canada are encouraging to see these legislations introduced, and we urge Parliament to move quickly and collaboratively to ensure these measures are passed into effect as soon as possible. Mr. Chair, our members are doing their jobs. They're arresting dangerous offenders and bringing them before the courts. We are asking that the justice system now do its part and ensure those efforts have lasting impact. Thank you for the opportunity to appear before you today. I look forward to your questions.
Ms. Dunn, over to you, 5 minutes.
Thank you, Mr. Chair. I just want to first address Mr. and Mrs. Best and say that I'm so sorry for the loss of your daughter. My name is Jennifer Dunn, and I am the Executive Director at the London Abused Women's Centre here in London, Ontario. The London Abused Women's Centre is a non-residential centre and provides women and girls over the age of 12 who have been subjected to abuse by an intimate partner, assault, harassment, exploitation, trafficking, and non-state torture with immediate access to long-term trauma-informed counselling, advocacy, and support. For more than 42 years in London, Ontario, our organization has supported women and girls who have been subjected to male violence, and every day we see how decisions made within Canada's justice system shape women's safety and their faith in the system itself. Today, I speak on behalf of survivors, their families, and frontline workers who stand beside them. Bail and sentencing decisions are not abstract legal matters. For some women, they are life or death moments. My first point is that bail must be trauma and violence informed. When a violent offender is released, survivors are often forced to relocate, leave work, or lose their job, or live in hiding. These are not just disruptions, they are losses of safety, identity, and stability. Bail decisions must reflect an understanding that violence is rarely a single act. It is usually a pattern that continues even after charges are laid. A trauma and violence-informed approach means recognizing that history and centering the victim's safety in every decision. This does not mean denying bail in every case. It means assessing risk with depth and compassion and asking, what will this decision mean not only for the survivor's safety, but potentially her life tonight, tomorrow, the next month, and could be over the next couple of years, depending on how long this particular court case takes to get to trial. My second point is to highlight Caitlin Jennings' story. In London, we remember Caitlin Jennings, a young woman whose life was taken in an act of femicide. Her case is a painful reminder of what can happen when the system fails to protect, but also of what happens when it works. The man charged with Caitlin's death had a bail hearing on November 2023, and he was denied bail. Superior Court Justice Leach denied bail after reading a 2-hour decision. Colleagues and I sat in that courtroom supporting Caitlin's family, and we were relieved to know that he would be held in custody until his trial. And while that did not erase the tragedy of her loss, it gave her family and other survivors a measure of reassurance that the justice system could prioritize safety when the risk was clear. Caitlin's father said, "This is one step in healing and justice for Caitlin." Now, his trial isn't until September 2027, but I could honestly not imagine this man out of custody for the next 2 years, knowing what I know. Caitlin's story reminds us that decisions around bail should not only be procedural, because behind every court file is a woman, a family, and a community living with the consequences. My third point is that systems must work together and be equally funded. Meaningful reform cannot happen in isolation. The justice system, police, and community support must be aligned and funded equally. At present, the imbalance is stark. The criminal justice system receives the bulk of the investment, while frontline social services are left to fundraise for survival. Yet it is those services such as counseling, safety planning, housing, and advocacy that help survivors stay alive long enough to see justice happen. Without stable funding for social support, bail reform will remain a theory on paper. Safety depends on collaboration, not competition, between systems. My fourth point is accountability and the role of sureties. Accountability is essential when bail is granted. Too often, high-risk offenders are released into the care of sureties who do not understand, cannot enforce their responsibilities. At the London Abused Women's Centre, we worked with a woman whose perpetrator was released on bail, with his mother as the surety. She had no control over his actions. She knew he breached conditions, and she did not report it. There were no consequences, and the victim's fear returned immediately. She could not leave her home without a safety plan. She couldn't even access our services without a safety plan. Sureties must receive clear information, training, and oversight, and there must be consequences for knowingly ignoring breaches. My fifth point is around balancing safety and fairness. The London Abused Women's Centre is not necessarily advocating for mass incarceration. Overly punitive systems harm those who are already the most vulnerable, particularly Indigenous and racialized individuals. But what we would like to call for is targeted accountability. High-risk, repeated violent offenders must face detention. But justice reform must also include investment in prevention, education, trauma support, addiction support, and the list goes on, through a trauma and violence-informed lens that stops violence before it starts. Safety and fairness are not competing values. They must coexist for justice to have legitimacy. In closing, every woman deserves to live free from violence. Every child deserves to sleep safely at night. And every system, from the courtroom to the counseling office, shares that responsibility. Reforming bail and sentencing is an opportunity to build a justice system that is trauma-informed, violence-informed, and survivor-centered. It is an opportunity to ensure that when we ask, will this decision keep victims and communities safe? The answer is yes. Thank you.
Thank you, Ms. Dunn. Over to you, Mr. Baxter.
Thank you, Mr. Chair and members of the committee. Just as I begin, Mr. and Mrs. Best, I would just like to commend you for your courage and the strength that you've shown in the face of the unimaginable loss of your daughter, Kelly. And my sincere condolences to you and to your family and to all those families who have been impacted as a result of violence committed by repeat and violent offenders. I want to thank you for the opportunity to appear here today on behalf of the Police Association of Ontario, representing more than 32,000 uniform and civilian police personnel from 46 police associations right across the province, including the Brantford Police Association. Our members are the dedicated men and women who serve on the front lines, keeping our communities safe every single day. Today, I'm here to address challenges that threaten public safety, our current bail system. As it stands, bail practices often allow violent and repeat offenders to be released back to the very neighborhoods that they have harmed, undermining public confidence and draining police resources. This is more than a procedural flaw. It is a cycle that emboldens offenders, increases community risk, and perpetrates a dangerous pattern of apprehension, release, and reoffending. The frustration our members feel is echoed by the communities they serve. To many, the justice system has become more than a revolving door. It feels as though the door has been left wide open. Recent data is cause for concern. Between 2019 and 2023, violent criminal code violations in Ontario increased by 20%. Nearly half of convicted offenders reoffend within 3 years, and violent repeat offences are on the rise. These numbers, combined with first-hand accounts from our members and victims, underscore the anxiety and the frustration felt by Ontarians and the immense challenges facing those sworn to protect them. The Police Association of Ontario has long advocated for practical, charter-compliant bail reform. We have called for evidence-based changes, such as expanding the list of reverse onus offences to include violent auto theft, home invasions, human trafficking, and more, lengthening the review period for prior convictions, and ensuring that courts rigorously scrutinize bail plans before release. These are not abstract proposals. They are grounded in the realities our members and community members face every day. Both major political parties have recognized the urgency of bail reform. Public safety is not a partisan issue. Well-designed bail reform that balances charter rights with community protection is in everyone's interest. The introduction of Bill C-14, the Bail and Sentencing Reform Act, introduced last Thursday, October the 23rd, marks a significant and long-awaited step forward. The bill addresses urgent shortcomings in our bail system. Its provisions, including new reverse onus rules for violent and organized crime, stronger bail conditions, and tougher sentencing for repeat violent offenders, respond directly to concerns raised by our members for years. This is an encouraging sign that the voices of frontline officers and the communities we serve are finally being heard at the highest level. These proposed reforms reflect the lived realities of our members, the experiences of victims, and the expectations of the public, and send a clear message that repeat and violent offending will not be tolerated in Ontario or across Canada. Let me be clear. Without meaningful change, the safety of our communities and the lives of police officers and the public remain at an unacceptable risk. Each release of a violent offender increases risk of tragedy in our communities. Ontario cannot wait for more lives to be put in jeopardy. Decisive action is needed now. We urge all parties to pass Bill C-14 immediately. Every day that this vital legislation is used as a political bargaining chip or a soundbite during question period leaves real lives on the line. Mothers, daughters, fathers, sons, sisters, brothers, friends, and families across Ontario deserve action, not politics. On behalf of the 46 police associations that we very proudly represent, I thank the Government of Canada for taking concrete steps to strengthen public safety and support those who work every day to protect it. Ontario's police personnel will continue to do our part in our communities, in the courts, and on the front lines to keep people safe. We look forward to working together to ensure that these reforms are implemented effectively and deliver the results that Ontarians and Canadians expect and deserve. Together we can and we must build safer communities and ensure that these reforms deliver a justice system that protects victims, not offenders. Thank you.
Thank you. We'll get a chance to go through probably 2 complete rounds, starting off with Mr. Brock for 6 minutes, Ms. Latanzio for 6, and ensuite Réal pour 6 minutes à son tour, suivi par Monsieur.
Mr. Lawton, in the second round, 5 minutes. Mr. Chang, Fortin, Leslie, Chang, 5 minutes each, except for Mr. Fortin, 2.5 minutes, as agreed. So I'll give the floor to Mr. Brock now. 6 minutes.
Thank you, Chair, and welcome to all of our witnesses. Thank you for participating. To Mr. and Mrs. Best, I am heartbroken, I am angry, and I am disgusted that I was once a member of a justice system that has failed you so miserably. I guess to really emphasize that point, every time that offender who took your daughter's life appeared in front of a judge and was granted bail, he promised to follow those conditions. And if he was released with a surety, that surety also promised that he would abide by those conditions. These are false promises that are given every single day in this country, and the justice system accepts it at face value, will often sometimes give warnings. Should you breach these conditions, you ought not to expect to be released a second time or a third time or a fourth time. And history and example after example shows us that these are promises that are not fulfilled and consequences not given to offenders. So if you could say to the government, what is the most important thing to you as survivors of a loss such as what you've suffered? What would be the most important thing that you could tell this committee when we write our report to the House?
It would be nice to have the criminals. It would be nice to have the criminals become accountable, no different than we're accountable as members of society. We sat in on a bail hearing, and the accused sat in a small cubicle in the detention facility, and it was like, geez, are we done yet? Like he's not engaged, he's not listening, he does not care. The bail hearing had to be extended by an apology of the justice because the defense lawyer, for 40 minutes, I'm not sure if he took 3 breaths, would not stop talking. As a result, we had to go back 3 days later, and then he was provided bail. Again, there's no motion, there's nothing. There's no feeling, and it's a slap in the face to the government that passed these features that we're living with today. It's a slap in the face to the police force that have to deal with these people.
He showed no emotion.
None.
He showed no care because he knew he was getting out. That's what this Liberal government's failed justice policies for the last 10 years have instilled within the criminal element in this country. It has emboldened criminals to do exactly what they are doing and terrorizing communities. Thank you for that. To the officers, both of you spoke about first steps. This was a good first step in the government introducing Bill C-14, but you would both acknowledge that while it talks about making it tougher for individuals to obtain bail, the same language that they used with the disastrous rollout of Bill C-48 by expanding the list of reverse onus charges, when you had members of the government, including the Prime Minister of the day and the former Justice Minister, proudly stating, "We delivered bail reform. These repeat violent criminals are going to be detained." We know that was a false promise, a false declaration, because we found ourselves right where we are right now with catch and release. Will you both agree with me that there is not a pathway in Bill C-14 for automatic detention? Yes or no?
I would agree with you, yes.
Right. It still vests discretion for judges in bail matters, particularly when you're dealing with violent repeat offenders, to still be granted bail. And the bill clearly states that when a justice makes a decision to release, it has to be on the least onerous conditions. I want to talk about that because that's one thing that we're not talking about in this committee, which is the sufficiency and the degree by which conditions need to be established. I have heard horror stories across this country of judges refusing to list conditions because it's an invitation to breach, or they're not addressing conditions reflective of the crime and the impact to the community or the victims, or they're making a joke of the promise to pay by requiring offenders to pay 5 cents. This is what's happening in downtown Toronto as we speak. Do you think that type of activism by our judges is appropriate to deal with community and victim safety?
Yeah, I think there's lots of work that we can still do around sureties. I think, in the Antic decision, it said that a pledge for a deposit performs the same function as actually giving a deposit. Quite frankly, that's nonsense.
Do you agree with that?
No, it's nonsense. And so, we need to do more work around sureties. We need to ensure that some sort of deposit is received by the court. We need to ensure that we're doing proper checks on sureties, that we don't have these sort of career sureties showing up repeat time and time again, vouching for someone who's been accused of an offense, that they're going to ensure that they abide by their conditions, knowing that they've put a pledge for a deposit, knowing that they're never going to have to pay that. It's never going to be collected.
Thank you, Mr. Baxter. Ms. Latanzi, 6 minutes.
Thank you, Mr. Chair. My first comments are for Mr. and Mrs. Beth. So just let me start by saying how deeply sorry I am for your loss. And your family story is quite devastating, to say the least. And it shows how devastating it could be when someone who's got a long record of breaking bail is released. So you've heard about us speak about Bill C-14, which was introduced last week by the Minister of Justice, which strengthens and makes a bail and sentencing tougher. So it was also made with the scope of also preventing, the incidents that happened in your family by happening again. So, it would require the courts to consider the offender's history, past breaches, violence before granting release. So from your perspective, how critical is it that the change to ensure that no other family go through what you've gone through?
It's an important step that this is a beginning to establish a framework that once it's passed, then that framework, as we carry forward, any deficiencies as a result of the experiences can be tailored to protect society.
Would you like to? Yeah.
Yeah, I think the other thing is that it's still giving the judge the opportunity to make a decision. And I think that our judges need stricter criteria when they're making those decisions. For example, she could still have let Mr. Hilton out, still the 3 times or whatever. But what we saw from those 3 times, that there was actual escalation in the charges from the first one to the third one. But she's still, it was still okay for that judge to make that decision. If there were some clearer guidelines put in place each time, if there's an escalation, if there's drugs, if there, whatever, our judges need more support in, besides just at their discretion. That's not good enough.
My next question is to you, Mr. Baxter. Mr. Morton. Sorry about that. From your frontline experience, how would Bill C-14's bail reforms change what officers face from day to day in keeping communities safe?
In Brantford, as I had stated in my opening comments, we are often arresting the same individuals repeatedly that have an outsized impact on both the police service and the criminal justice system. If you look at our crime severity index that was posted for 2024, and the comments made by our chief, Chief Saunders, a decrease in the crime severity index can often be caused by 1 or 2 individuals that are being detained in custody to cause those charges or offenses to stop happening while those individuals are in custody. And by keeping those repeat violent offenders in custody, it helps protect the rights of the victims and the community.
And how would you say that Bill C-14 delivers on the concerns raised by police officers?
I would say that Bill C-14 addresses quite a few concerns that the Police Association of Ontario has been advocating for over the last several years in regards to expanding reverse onus bail hearings, along with the fact that it's making more stringent conditions for judges or justices of the peace to retain individuals in custody.
Would you say, in your opinion, that consecutive sentencing would also help?
I would say that consecutive sentencing, if it was used appropriately, would help indeed.
Okay. And we've heard time and time again that there's a coordination between provinces and the federal government. So in your opinion, that coordination would mean what? Do you believe it is needed to ensure that these reforms would work on the ground?
I believe that a standardized training program, I was shocked to learn that justices of the peace don't have standardized training across Canada. I believe that that would be instrumental in making sure that the criminal code, along with the charter, is properly applied when dealing with repeat violent offenders.
Can you give us a little bit more details in terms of what would the training entail? What would you want to see in terms of the training specifically?
Currently, right now, as I had stated, I don't believe that there's any standardized training for justices of the peace across Canada. It would be nice to see that training specifically around maybe the latter principle, along with the opportunity to make sure that sureties are staying in compliance with addressing the concerns of not having the individuals just out, like President Baxter had said about the professional sureties that just come in. They may not have had any interaction with these individuals for quite some time, and then they're vouching to say that they're going to keep an eye on them with no real consequences if those individuals end up breaching those conditions.
Thank you. Merci. À vous, Monsieur Fortin, pour 6 minutes.
Thank you, Chair. Thank you, all witnesses, for being here with us today. I'll also like to extend my sincere condolences to Mr. and Mrs. Best for the death of your daughter. Right now, to place an accused on bail, there are 3 criteria to be assessed by the court. First of all, do we believe that there's any danger that the person may not appear in court when required? Secondly, is the person a threat to public safety? If the person is released, he may place people in danger. And the third criteria, will public confidence be undermined if that individual is placed on bail? The 3 criteria are in force right now. And what we are talking about is to reverse the burden of proof. So the accused has to prove that he meets the 3 criteria, and that onus is being reversed. Rather, it's the opposite. The Crown has to prove that the person may not appear in court, is a public danger, or doesn't respect the administration of justice. So the accused is being asked that they are not posing any danger and they will attend court for their trial. So in your opinion, this reverse onus, will this change anything? And if so, I would like you to tell us. Maybe Mr. Baxter first.
Sure, thank you. Yeah, so for the on a reverse onus offenses, first of all, what we're talking about here is limited scenarios where the starting point for violent repeat offenders is detention, and then the onus is on them to show why they should be released from custody. These changes, to me, along with clarification of how justices should be applying the latter principle, the principle of least restraint, seems to me that once this bill becomes law, it's going to have a real impact on this group of people that we're talking about that are continuing to victimize our communities.
Donc, si je comprends bien.
So, in your opinion, we could detain people before their trial if we were to apply that. Is that what you're saying? They could be detained while waiting for their trial.
Yes, we would. That is the intent. We would detain people who have met the criteria, who are dangerous, who are violent, who are repeat offenders. We would hold them in custody ahead of their trial, so they can't be out re-victimizing communities.
L'Association du barreau canadien.
The Canadian Bar Association claims that this reverse onus principle is useless. Have you talked with representatives of the Canadian Bar Association?
I've not spoken with anyone from the Canadian Bar Association about this.
Okay. Présentement, les
Right now, statistics tell us that in our prisons, 72% of people detained are there not because they were convicted of a crime, but because they are awaiting trial. Don't you think that those statistics are disturbing to believe that our prisons are simply keeping people who have not been convicted? Only 28% of those in prison will be convicted felons. Is this not disturbing?
We have to ensure that we have safe communities, and the way that we have safe communities when in the face of repeat and violent offenders, those accused of the most serious offenses and violence crimes, that they remain in custody until their trial. That is how we can keep our communities safe, and we see it far too often where people who are accused of very serious violent offenses, terrorizing, victimizing communities, they're released, and they continue to commit these same or similar violent offenses.
Je comprends.
I understand. Mr. Baxter, what we're talking about is the seriousness of the charges. So the Crown prosecutor decides to accuse someone of murder or homicide or any other crime, it does not necessarily mean that the person is guilty. Don't you think it's better to maybe look into repeat offenders instead of saying somebody has a blank criminal record but accused of a serious crime, wrongfully or rightfully, and meets the criteria for release? Shouldn't you focus on repeat offenders, those who have already been convicted for similar crimes? Is it not better to have this balance in the justice system?
I think, first of all, the Crown's not deciding who they want to charge or who they want to accuse. The police have gathered evidence. They've conducted a criminal investigation, and through that investigation, they've determined that someone, they have reasonable probable grounds to believe that someone has committed an offense.
Mais
and if
je suis
it
d'accord
reaches,
avec vous. Je m'excuse, je ne veux pas être impoli, mais
I'm sorry, I don't want to be impolite. Time is running by. I think I have just a few minutes left. I understand. I have no doubt that the police officers are doing a good job, because we're trying to find the right balance between public safety and respecting the freedoms of everyone. Shouldn't we use repeat offense as the criteria for reverse onus instead of the seriousness of the crime?
sorry, did you say I can answer? Yeah, I think we can use both. I think we should be looking at the seriousness as well as the repeat offenders.
Merci. La deuxième ronde.
The second round is starting. I'll start with Mr. Lawton, Mr. Chang, followed by Fortin, Mr. Leslie, and we'll end with Mr. Chang once again. Andrew.
Thank you to all the witnesses for being here, and to the best, I cannot convey enough how deeply sorry I am for your loss and that the system failed your family and your daughter so much. Ms. Dunn, I'd like to start with you, and just by way of disclosure, my wife does sit on the board of your organization, so I'm very familiar with the work, and we've been supporters since long before then, so thank you for your advocacy on this. We heard Mark Roskamp, the St. Thomas Police Chief, before this committee, and he had said in another session that 58% of those charged in St. Thomas with offences related to intimate partner violence are repeat offenders, and many of those are on bail. You deal with the victims of this. Does a stat like that surprise you, or does that conform with what you understand about the perpetrators of intimate partner violence?
Thank you so much for the question, MP Lawton. I think, that goes right in line with what we see here on the ground. And what is even more important maybe to mention is, that doesn't necessarily include all of the women who choose not to report to police, right? And so I think the numbers are not shocking, and Stats can put out a report just came out today and it showed that between 2018 to 2024, IPV charges were up by 17%. And that statistic is not shocking either, because we are busier than ever. In the past year, we've had over 10,000 service interactions at our tiny little organization here in London, Ontario. So
there is a bill before this House of Commons, a Conservative bill that would treat the murder of a current or former intimate partner as first-degree murder, regardless of whether it was planned or deliberate. It would also create a new specific criminal code offenses for assault of an intimate partner and criminal harassment of an intimate partner. Would these measures be ones that you would encourage the House to pass?
Absolutely, I would. I think that we need to look at those types of crimes individually. I think that when we're looking at intimate partner violence, it is very much a gendered issue, and violence against women is not on a decline. And I think it's very important to look at any type of law or legislation that can support ending violence against women.
In your initial testimony, Ms. Dunn, the trauma and pain that offenders being released on bail causes to women, to victims, you mentioned that they have to move oftentimes. What is the process itself like of these bail hearings? Does it respect the women who are dealing with trauma and dealing with these offenses in your experience?
Absolutely not. We have had women who refuse to call the justice system anymore. They call it the legal system because they feel as if they are not seeing enough justice done. It is very, very much a problem with, bail happening and women not being informed or it being difficult for them to find out what's happening next. And that's an ongoing issue. And it's organizations like ours, and we're so thankful to have such amazing community partners here in London, Ontario. And we can work together to support women who are who have been subjected to this type of violence and who are involved in the criminal justice system at no fault of their own, navigate through that and figure out, what is happening next, because sometimes it's like I said, very difficult to get information.
Thank you. Moving to you, Mr. Morton, we have heard from this testimony before a concern that there is this wide gap between legal theory and experiences on the ground, the realities that your members and your colleagues have to contend with. And I note some of the Liberal witnesses have come from academic backgrounds where they have never even spoken to, as part of their research, victims. They are solely focused on the rights of the accused. What is the danger of that way of approaching criminal law?
The danger in regards to that is we are putting the offender's rights above families and victims of these serious and violent crimes that are happening, and it's not taking a fulsome approach in regards to reviewing what needs to be changed or what should be considered to be changed moving forward.
Thank you. Thank you. Wade, 5 minutes.
Yeah. Thank you, Chair. To Mr. and Mrs. Best, we are very sorry for your loss, and my sincere condolences to you and your families. So my very first question goes to Ms. Dawn. In your work with survivors, how often do you see cases where violent partners end up reoffending while on bail?
We see it all of the time. The one example that I gave where we were working with a woman whose mother was the surety for the perpetrator, that, that was not a good situation here for the woman that was accessing service. I think, like I said in my speaking notes, the woman could not even access our service without a safety plan. It was difficult for her to come to a service like our organization would provide. And so we see this time and time again. For example, when I told the staff here that I was going to be appearing before all of you, I had numerous staff members want to share stories with me to bring forward. So this is not an unusual circumstance for us here.
Thank you. And in your experience, what is the best way for the justice system to protect victims while still being fair to the accused?
We think it's very important for the system to work as much as they can right now, the way the system is structured, with a trauma and violence informed lens and trauma and violence informed approach. I think it's really important, to look at what maybe targeted accountability could look like. You all have a very big job to do, and we need to see high-risk repeat violent offenders to face detention. But we have to remember that this is not one size fits all, right? And we really have to recognize that, without the proper implementation in place, it's just simply not going to work. So everybody has to work together in order for it to work properly. And what I mean by that is that, if there's a woman on the other side of what an accused is going through with the criminal justice system, she needs to be informed every single step of the way. There needs to be accountability from the criminal justice system in that regard as well, not just for the accused. Victims do have rights as well, and it's really important for those to be considered every step of the way.
Thank you. And from your perspective, how would making it harder to get bail help keep women and families safe?
When a violent offender has been released on bail, women are constantly fearing for whether it's their lives or their safety. They cannot leave their homes without fear. They are constantly looking over their shoulders to see, what's going to happen next. And it's very difficult to live like that. And nobody should have to live like that. And just to be clear, it's very important that those types of experiences are considered when looking at changing any legislation or law. But the reality is, organizations like ours, we are working every single day to work ourselves out of a job. We don't want to be in 2025 having to provide service over 10,000 times in a year. And we really need to make sure that every single system is working together to provide every opportunity for real justice.
Thank you. And my last question to you is that beyond changing the law, what kind of support do we need to make sure that reforms actually keep women and families safe?
You have time for a brief answer, Ms. Dunn.
Sure. Quickly, I think it's very important for all of the systems to work together. So I think this is an opportunity to, I think, like I said in my speaking notes from, I have it open right here, the courtroom to the counseling office. Like, we all share the responsibility to support both survivors and victims and families, and also the perpetrators of the violence. And that comes with education and prevention and proper funding all across the board.
Thank you.
2 minutes et demi. Oui.
Merci, Monsieur le Président.
Thank you, Chair. Let me come back to Mr. Baxter. It's not that the other witnesses are not interesting, rather. Mr. Baxter, Madam Best told us something that we may add a condition, maybe drug addiction. I don't remember the exact words she used, but she talked about considering drug addiction when considering releasing someone on bail. In your opinion, is that a criterion that should be added? And in any case, I would like to know what you think about the criteria. Let me repeat them. Make sure that the person appear in court when required, the person does not pose a risk to public safety, their release does not undermine confidence in the administration of justice. So, Madam Best thought about adding a condition related to drug addiction. Mr. Baxter, what do you think about that? What additional criteria should be added?
I think that if we are continuing to talk about repeat and violent offenders and their drug addiction as part of that, then that becomes part of the conversation and part of the context that takes place at a hearing. At a bail hearing. I think, we have to remember that, the reforms that we're talking about here, we're not talking about everyday petty theft, right? We're talking about the worst types of repeat offenders who are defying rehabilitation, flagrantly running afoul of the law, and continue to victimize our communities. And that's who we're talking about. And if we're looking at reverse onus criteria as to whether or not they should be released within those 3 criteria that you have laid out, if they have alcohol or drug addiction issue, that's going to form part of the context that will take place in the bail hearing, part of the considering factors.
Le fait qu'il y ait ou pas récidive, que ce soit un crime violent.
Whether they are repeat offenders or not, it's not a violent crime. Drug addiction, drug or alcohol addiction, those are the conditions that should be added, if I understand you well.
Can you repeat?
Je disais le fait qu'il y ait un problème d'addiction, que ce soit une récidive.
The fact that there's addiction, repeat offense, violent crimes, those are the 3 criteria we should consider. Is that what you're saying?
In terms of the drug addiction, whether it's considered, that's always going to be considered by a justice during the bail hearing anyway. context is there now for whether we're talking about a reverse onus offense or a not reverse onus offense. The person's alcohol or drug addiction or dependency is going to form part of the conversation, part of the discussion that will take place in bail. And we have seen times, mental health also plays into that. And we have seen times where folks are released and provided with opportunities to seek treatment and counseling.
Thank you. Merci.
Thank you.
Brandon, 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. and Mrs. Best, Michelle, Ron. I want to thank you for your courage in coming here today and sharing your story with such incredible composure, given the circumstances, and for your relentless advocacy and efforts to try to change Canada's bail system in the aftermath of the terrible tragedy that your family faced in honor of Kelly, but with a focus on ensuring that other families don't face the same devastation that yours had to. I know Kelly a little bit, and she was a wonderful human being with an incredibly bright future ahead of her, and she did not deserve to have her life taken by a man who should have been behind bars. I am so sorry for the loss that your entire family has faced, for the loss of Travis, her fiance, for all of those that knew and loved her, and frankly our entire community, my hometown of Portage, which was badly shaken when the news came out, which turned into pure disgust when the circumstances of how this tragedy came about. Kelly faced the consequences of political decisions that put the rights of criminals above the rights of everyone else. Her death should not have happened. Now, the individual who killed your daughter was given bail 3 times within 2 weeks prior to this tragedy. How does it make you feel to realize that the system as it currently is set up seems far more concerned with his rights than the safety of your daughters?
It's a feeling of like you just feel defeated because there's so many things that go through your head when you ask a question like that. Just the fact that there's just no, like they just simply don't, the suspect just simply doesn't care about society. He was released on his bail 9 months after spending time in prison, September 5th. September 6th, he absconded. September 7th, he posted on his social media, fresh out of PWEZY, no regard for the family, nothing. Monday, we discovered from Victim Services that he was released on Friday and left within 6 or 7 hours. So 4 days after we discovered that, Tuesday we were at a press conference, and at 3 o'clock that afternoon, 4 to 5 days after he was released and absconded, a warrant for his arrest was issued, and he was picked up, I think, within 20 minutes. So, whether or not that answers your questions, when those types of questions come up, those are the things. It just leaves you bewildered how it can happen.
It goes to show that our police are doing their level best, and thank you all for the work that they do. Now, you've lived through the worst imaginable outcome of a failed system. If you could speak directly to the lawmakers that have defended for years the status quo of this system, what would you say to them?
To speak to what you hear about rehabilitation, the importance of rehabilitation, and they need help, and it's in this case, and I think in most cases, if it's a justice or a judge that's giving this person bail, not only you're not doing the family any favors, but you're not doing the individuals any favors. They just can't, if you let that individual out, they just don't understand it, and they're going to go and do exactly what they were arrested for previously. And
I think my comment would be, we need change. We're continuing to do the same thing over and over again, expecting a different result from people who are not able to make different decisions. And by just releasing them back into our communities, we're giving them the go-ahead to continue their behavior. This is not something we talk about for initial offenses. This is repeat, and I think that that's a key word. And if I could speak directly to them, please make these changes.
Thank you. And just quickly, what message does it send to victims' families when someone who repeatedly breaches these conditions is yet given another chance by a judge?
It gives the message that
There's a button right in front of you, Michelle.
Okay.
Perfect. You'll see a red thing go on.
we want them. We felt at a loss. We felt discouraged. We felt that his immediate needs were being put over the situation that our family has been put in. She's a huge loss, not only to our community, as Brandon mentioned, but to our family. She was a pillar in our family, and it didn't matter. And no one asked us the question, and no one considered his previous behaviors either. When you talk about the fact that previous drug use should be mentioned in bail, there was no mention of his previous history. His defense lawyer made us think that he had previously been one of Senta's helpers. So it's important that the accused have a chance to speak and that the judge have a chance to make some better assumptions based on history.
Thank you. Thank you both. MP Chang for 5 minutes.
Yeah, so I got one more question for Ms. Dunn. You have mentioned the danger women face when violent partners are released after multiple breaches of no-contact conditions. Bill C-14 now requires judges to consider that pattern of violence and expand reverse honest provisions for repeat offenders. From your perspective, how important are those changes to keeping survivors safe?
Thank you so much for the question. I think that those changes are very important. I think those changes should come with perhaps increased education and training for the judges making those decisions on the nuances of intimate partner violence and sexual assault and human trafficking and anything that falls under the spectrum of violence against women. It can't be assumed that all judges would have all of the information that they need to move forward with a decision, and so I think that would be really important. But those changes with this new bill in front of all of you, I think are a good step forward.
Thank you. And my last question is to Mr. Morton. Would you urge all parties to support Bill C-14, and why?
Yes, I would encourage all parties to support Bill C-14. As I'd stated earlier, the Police Association of Ontario has been advocating for lots of these changes over recent years with the full support of all associations across Ontario, at least. I can't speak nationally, but in Ontario, all police associations are in agreement that things need to change.
Thank you. I have no further questions, Chair.
Okay, thank you. And presuming to speak on behalf of the committee, but I do want to thank you again, Michelle and Ron, for your courage today in coming here. And this testimony has not fallen on deaf ears. It did, again, take great courage for you to come here. And on behalf of the committee, personally as well, I do want to extend my deepest condolences on the loss of Kelly and to all those that loved her and knew her. So thank you. And I'll leave, obviously, Mr. Best, I will leave you some words. We do have a couple minutes before we have to switch over, but I do want to just thank the rest of the witnesses as well for their important testimony.
Thanks, Mark. Just, it's important for everybody to imagine when you arrive at a crash scene and see the vehicle absolutely obliterated and say, boy, my girl was in there. and you're very, very thankful that members of law enforcement are on that scene, and they don't let uncles in, they don't let aunts in, they let in my wife and I and her fiance, and we have to be very, very thankful to have those law enforcement people present at those scenes, because they are absolutely terrifying, and that is one of the chain links, if you will, that's occurring as a result of this policy of just essentially these criminals are just waiting, looking at their watch if they have one on, and looking at their lawyer and saying, "Did I get out? Yes or no?" Because I got to get back to my cell. I mean, I just wanted to say that in closing, because it's really important to law enforcement. We're really helpful to Kelly's fiance, to my wife, and to myself, and you really appreciate it, because it's a very, very haunting thing to go into.
Thank you. Thank you. We will suspend for a few minutes to switch over to the next round, and we'll resume in about 5 minutes. Thank you.
Okay. Pretty crazy testimony to hear. It almost puts you to tears. What are we doing? Come on, guys. Keep it cordial in chat here. We're all adults here. I haven't been keeping up too much with chat. I also did have to briefly cook some food there just because I was extremely, extremely hungry. Now, the next witnesses are more police chiefs, and I really just wanted the first hour because I wanted to hear from common citizens and how they deal with this in their daily lives. Now, I bet you the next I'm not going to cover the next 2 hours. You guys are welcome to, watch this on your own, but for me, that was enough. I know what's going to happen in the next 2 hours. It's going to be should we do Bill C-14, sorry, or should the Conservatives' bill be prioritized? Do you know what I mean? It's gonna kind of go back and forth on, oh no, my bill's better. Oh no, my bill's better. So, we already know how that was. We already know how that's been going. So I don't really need to listen to any more of that. It's quite depressing, to be honest. But yeah. So tomorrow, it's going to be mostly in French the next 2 hours. Yeah, I'd imagine that too. A lot more French. And they'll just be debating kind of, oh, is Bill C-14 good, or no, is the Conservative bill good? And yeah, it's just like a partisan issue, which should not be partisan in the first place. But we are live for question period tomorrow at 2 p.m. Standard Time, same time as we were today. I haven't double checked to see what committees there are, but I think there's a committee in the afternoon. Oh, there's a lot of committees in the afternoon tomorrow. I'll double check to see which one we're covering. I think it's ethics. Yeah, ethics is the one that we're covering tomorrow, which is great with Cooper and Barrett. So we'll do that in the afternoon. We'll have question period at 2, and that's it. That's it for today. Tomorrow looks pretty slow. Wednesdays are usually pretty slow, but it is what it is. So I will see you guys tomorrow. Thanks, everyone, for tuning in and watching, and have a great rest of your evening. Go Jays. Cheers, guys.